Good afternoon, High-10 George Realty and Coldwell Banker Commercial George Realty agents. It's a pleasure to be here with you today. Today we'll just take a look at the car commercial purchase agreement, and I'll go over just some of the highlighted spots that I think is important to pay attention to because the grid's going to look pretty familiar to all of us. So I'm going to go ahead and share screen and start on that. Okay, so this is the California purchase agreement, commercial purchase agreement, car form. So we already went over the AIR forms, and these are perfectly okay to use too, these car forms that they've made for us. So this is all going to look very familiar. I'm only going to hit what I think that is things we should be paying attention to, because if you look at the grid here, everything's going to look extremely familiar to us. We're all used to this type of grid. Here I've highlighted a couple of things. The seller to credit buyer for closing costs on this particular agreement is down at the bottom, if that's applicable to your transaction. And additional seller credit terms does not include buyer broker compensation. So we have to be really careful that we're not adding anything in where it shouldn't be, okay? So here on this agreement, Q3 is where you would check the box for your compensation. So you check the box here and put your 2% in, 3%, 4%, 5%, whatever the case may be. And remember, we still do require a buyer broker agreement. I'll briefly touch on that after this. It's really important that you have those in place because the other agent may want to see the last page of your agreement to make sure that you did have it. And please don't ask for more on this agreement, as we've always said in residential, than what is on your buyer broker agreement. Okay, so you can always go down if you had to, but you can't go up. You can't up over your contract, your buyer broker contract, okay? Agreement for compensation. So here in N3, the evidence of representative authority is 3 days after acceptance. A lot of times you're going to have that ahead of time, or escrow may ask for that documentation. So they give you 3 days after acceptance, so not to worry if you don't have it. I always think it's good to check ahead of time because you want to make sure that the people executing the contract are duly authorized. You can look on the California Secretary of State website, or you can ask them for the documents. It's as an agent, we always check ahead of time though, but escrow will also do that. Okay, so these are all going to look familiar. We're not going to go over all of this. This is really important not to miss R. I recommend that you check both of these boxes. It's super easy to miss because it's a very skinny box. So on R, I would check for the income and expense statement and the tenant estoppel. So I'm only going to be pointing out things that you wouldn't recognize on, up in the grid that we haven't dealt with before, but R is really important to check. Okay. And these are the things I just highlighted that automatically populate with this agreement. Of course, in an agency disclosure will. So here, so when you're, and I'm going to go over the contract cancellation because we always have questions on that. When you're canceling a contract, it's a good faith cancellation in accordance with paragraphs, right, in the agreement. So if you look here, the reason I highlighted this is because a lot of times it's going to be because of the inspection or insurance, right, on a commercial purchase. So 8, C or D, I'm going to pull up that form next, but you would be canceling if applicable in accordance with the paragraph, not because you lost your job, which I've seen actually on a cancellation, not valid, not because your dog ate your homework. I'm teasing, but it has to be referenced in the, referenced back to the contract for your reason for cancellation. And it cannot be other lost my job. That doesn't work. Okay. So it has to reference back to the contract. And for a buyer's agent, mostly it's going to be item C or D. It's either going to be the investigation of the property, or it's going to be the insurability of the property. Okay. So cancellation, I want to really go over this. If the buyer does not remove a contingency within the time specified, the seller needs to issue a notice of perform. You can't just cancel. You can't cancel escrow. You have to step this process. So if the buyer does not remove those contingencies, the seller, after first giving notice of a buyer notice to perform, then they would have the right to cancel the agreement. But you can't jump and try to cancel or all of that. Just step yourself and go in line. All the forms are lined out for us. Okay. Let me move down. So this is number 12, tenancy related disclosures. If there's tenants in this property that they are going to purchase, then you should have copies of all of the current leases and rental agreements, service contracts, meaning things that are going to survive the close of escrow, service providers that are on contract or that, will still be there. Maybe there's some leased items on the property that will survive the, close of escrow. So you're going to need all of these items. Income and expense statement, it's only applicable to be provided to the buyer if you check the box at 3R. That's why that's important. And it's going to be the books and records for the property, if any, including a statement of income expense for the 12 months preceding acceptance. So that would be really good information for your buyer. So make sure you check the box to give them everything that they may need to make a sound decision. Tenant estoppel certificates, only if checked. You're going to get the leases per contract, but to get the estoppel certificates, you would have needed to check 3R, as I showed you up above. So make sure you check those boxes if there are tenants in place. So the seller is going to make a good faith effort to obtain tenant signatures, but the seller cannot guarantee that the tenant will cooperate. In the event the seller cannot obtain the signed estoppels within the time specified in the contract, then the seller shall notify the buyer and provide the unsigned estoppel that was provided to the tenant to the buyer. And you would probably do that through email, make a note. Now, I don't know what a lender would think about that. If a lender requires estoppels, I'm only staying on, my lane. But if something like that happens, you may want to inquire, is that going to be something that the lender's going to accept? Because the contract clearly states that they can give you an unsigned estoppel that they tried to get the buyer to sign. So I'm just pointing out little differences that we may want to pay attention to on this particular contract.
Michelle, a question or comment on that. And the MLS, for instance, let's say it's a 3-4 units, and they put in a rental paying 2,500 or whatever. And then when you go over there, when the tenants, they tell you differently. I'm not paying that, I'm paying much less. And as the lender is guiding the loan based on the income that it shows on the MLS. Things like that. I tell you, because it happened to me a couple of times.
Well, I would think a lender, Peter, would want the actual documentation of the tenant estoppel.
If there's a discrepancy, you gotta rectify them. You gotta make sure which one is correct.
Yeah.
That's the point of the estoppel certificate.
I know, I understand the point, but again, I represented the buyer getting the loan. And there's the issue that I got a couple of years ago.
But the lender shouldn't be relying on the MLS. It would be, it would be really kind of not very good. They need to be relying on a lease copy, on an estoppel. A lender cannot rely on the MLS.
Okay.
Yeah, at all.
Gotcha.
Yeah, and I don't think they would. I think, but as an agent, it's good to notice if there's any discrepancies. So you can check the lease agreement closer. You can make sure you get that estoppel so that you know you have the right rental amount, because that makes a difference on loans. Yeah.
And issues like that, Peter, is something liable for listed for the buyer to say, you know what, forget it, then I'm gonna cancel this. Because you're telling me this is the income that they have, but then when we go over there and talk to the tenants and ask them how much paying, there's a huge difference between what you're telling us
Yeah.
and what they're paying.
Then it's a material fact, you have the right to cancel it,
Okay?
but you have to give notice to the other party.
Yeah, of course, no, I understand that. Okay, go ahead, please.
So any rebates or, for instance, concessions, you always want it. By the way, if it's a newer tenant, you want to look to make sure that they're all of the abated rent, like sometimes when we write leases, especially if they're long-term, there could be 5-6 months of a rental abatement. So you're always kind of scanning for that for your client. So you would want to know all that to let the client know if there's any rental abatement or anything still in play on those lease agreements. Most of the time, I would say 95% of the time it's not, but it's just something to know in the back of your mind as a good commercial agent to be looking for that. Okay. So changes during escrow. They have a whole paragraph here it's very quick and to the point. So prior to close of escrow, the seller may engage in the following acts subject to buyer's rights: rent or lease a vacant unit or other part of the premises, alter, modify, or extend existing lease agreements at least 7 days prior to these proposed changes. The seller shall deliver written notice to the buyer that they want to make these proposed changes. Then the buyer has 5 days to review the proposed changes. And it has to all be in writing, of course, and may give the seller notice of the buyer's objection to those changes. So in which case the buyer shall not make the proposed changes. Now, why is that? Maybe there's 2 vacant units and the buyer's really looking forward to, renting it out themselves at what they feel is market value. They probably don't want the seller to lease the units. So just be aware of that. That's a little bit different in this contract. So I'm just pointing out those types of things. So again, I really want to touch on the right to cancel. You have a right to cancel providing you are within your contingency periods as a buyer, or if the seller has a right to cancel if the buyer's not performing, and that could be the initial deposit. It could be they're not releasing the contingencies, removing them. You first must provide a notice to perform. Okay, so the buyer right to cancel the same way. If the seller's not performing or maybe providing some disclosures that were required in the contract, they first have to notice to perform the seller. Okay. So demand to close escrow, you have 2 days on a notice to perform. Until I read this really close, I said, oh, I thought it was 2 days. Demand to close escrow is 3 days. So if you send a demand to close escrow, then it shall be given the other party at least 3 days after delivery to close the escrow. And the demand may not be delivered any earlier than 3 days prior to the scheduled performance day of close of escrow. So I always get questions about how am I counting? So I'm going to go through that since I said the scheduled performance day. Okay, so on the repairs, the only reason that I highlighted that, because if seller agrees to some repairs on the property, they may do it, themselves, or they may hire somebody, but the seller shall obtain and provide to the buyer the invoices and paid receipts for the repairs performed by others. And if they did it themselves, they need to provide those receipts as well, and prepare a written statement indicating the repairs performed by the seller themselves and the date. Provide copies of invoices and paid receipts and statements to buyer prior to the final verification, you need to provide those receipts. So I know a lot of times we kind of skip that, but there could be a buyer that says, give me the receipts, right? Even if the seller is, you know, you have to provide a written statement of what they repaired, okay? So make sure you're paying attention to that. Final verification, as with all contracts that we're dealing with on car, is not a contingency of the sale, okay? So I only highlighted number 29, not only because it's a big deal, the ADA Act. So if the buyer is buying a building, they may want to have a consultant. You know, we have normal inspections, but they may want to have a consultant look at what may be required by the ADA, or if it's complete. So I just highlighted that to kind of clue you in, right? Isn't there an inspection that can do that, right, Peter?
Which one's better?
For ADA, they can look
Yeah,
and see if the building's compliant.
Yeah.
You and the city.
Yeah, you hire as the CASP, C-A-S-P.
That's right.
C-A-S-P.
Okay.
It's, you know, you do the inspection, they write your report, and it's about $500.
Yeah, and it's worth it, right?
It's
If they're
worth it.
purchasing the building. And of course, they can check with the city, you know, to make sure there's nothing documented on that needed to be done.
Michelle, in some cases, it's a building, 1960 or whatever building, and then if those inspectors will come and they say doors needs to be adjusted or whatever.
Then it's up to landlord, the landlord has to comply with that.
Okay, because the owner is gonna say, wait a minute, the building is like that, I bought it like that, it's been working like that. Now you guys came with the new regulations, they say, ramps and wider doors and stuff like that. We don't have that installed, though.
You mean, your grandfather in? Maybe,
Yeah, grandfather.
Maybe you can do that in rare circumstances, but most of the time, it will make you do comply with the ADA requirements.
Okay.
You know, unless it's very difficult for the landlord to do that, you're supposed to do it.
Yeah, like Peter said, get the CASP inspection, and then, you know, you request for those repairs
Yeah.
like in a normal process. And that's a negotiation point. Yeah, okay. So the counting of days, it can get really confusing. So after acceptance, if a scheduled performance day for any act required under this agreement, including close of escrow, lands on a Saturday, Sunday, or legal holiday, it moves to the next day, the next business day, okay? So that is called the allowable performance day. So I always get questions, hey, the contingency is ending on Saturday. No, it moves to the next business day. Now you still do your notice to perform or whatever, your notice to remove contingencies. But remember, they don't have to perform until after the weekend or that legal holiday, if it happens to fall on those. So just be aware of that for your day counting. I actually think this paragraph is really important to read because it goes into further how to count the days, okay? So here on liquidated damages, so if a buyer fails to complete this purchase because of their default, the seller shall retain as liquidated damage the deposit actually paid. So this isn't like AIR where you have to put a figure in the liquidated damage clause, right? It's the amount that you put into escrow. Because remember, we tell you that it's not capped on a commercial. So they kind of cap it here for you. It's the amount already paid as the deposit into escrow. Okay, so when you're bringing in additional funds, I'll show you how to either include it into the liquidated damage or not. As a buyer's agent, you probably don't want to include it, okay? So it's telling you right here, at the time of any increased deposit, the buyer and seller shall sign a separate liquidated damage provision, which is CAR Form DID. anytime you bring in more deposit, make sure you have the DID to back you up. So I am going to flip to the DID right now, just to show you. Right here. DID, delivery of additional deposit. And I think I put a copy in your package at the back.
You know, if the additional deposit is for extension of escrow or extension of the due diligence period, then that portion of the money should be stipulated to be released to the seller in consideration for the extension.
Right.
You know, so it won't be included in the liquidated damage. That's a better way to handle the additional deposit because you give the buyer some additional time, so the additional deposit is for the consideration of the extension.
Oh.
Okay, yeah, that makes sense.
Yeah.
Mm-hmm.
And it,
That
okay,
everybody is clear that amount is not refundable.
Not refundable.
Yeah,
Correct.
and it will say that right on the amendment of non.
right.
So if you bring in additional funds, you know, into the contract, not in the manner Peter is talking about, like if you're giving something to the buyer, you want something back, which could be the release of funds. This form is required delivery of increased deposit and liquidated damages. So you would fill this out. Number one, they're depositing on the date, how much, are they using cashier's check, personal check, or wire, payable to probably escrow, right? It's going to be payable to escrow. Buyer hereby increases the liquidated damage deposit to, you would put that here. Now, if they're not including that, you look at number 2, the big bolded paragraph of buyer and seller have agreed to liquidated damages because they initialed it in the agreement, but you don't want this next portion to be included. You just check the box here, is not incorporated or made a part, okay? And then everybody signs it right here. So that's a record, and then it's also record that you did not intend and to put that into liquidated damages, especially on a commercial contract that's going to be very important for you. So just get used to that. It's a simple form. They've made it just a single page.
Is this similar like we call per diem on single home? When you late close, you charge $100 or $200 per day if it doesn't close. It's something similar, no?
Yeah, you can name anything you want, but it was, you know, that's the consideration for doing something that extra.
Okay.
So I'll briefly touch on a cancellation.
Mhm.
So there's 2 parts to this. One cancels escrow, and the second page handles the disposition of the deposit in escrow. So this first page is canceling the contract. Okay, so right here, down here, both paragraphs are escrow instructions to the escrow holder. So it could be either the buyer or seller, a one-party cancellation. Who's canceling this? Or is it mutual? If it's proposed mutual, or is the buyer canceling it? Usually I just see the buyer. Now here's where you need to pay attention. As permitted by good faith exercise of paragraph, if it was the inspection 8C, you don't need to say anymore. You don't put something weird here. Just, which paragraph are you canceling under? It's either 8C, 8D, it could be the investigation. It could be that you can't get the insurance. Now, you can cancel providing you haven't removed your contingencies. So make sure that when you're doing, when you are removing contingencies, that's a very serious business. Make sure that you can get, that your buyer can get the insurance, or you ask for an extension. But you always want to cancel good faith exercise of which paragraph. It's usually going to be 8C or D. Okay. So this is the canceling of the contract. Now we come to page 2. This is the disposition of the deposit and cancellation of escrow. Okay, so you're going to come here. Please put the escrow number here, what the escrow company is. Sometimes I see that people don't fill this out. Kindly fill this out for us because we're going to ask you to. Okay, so normally what I see when somebody's canceling inside of their contingency periods, mainly they're going to check one. Okay, and it's going to that the seller does authorize the buyer's deposit to be returned to them, less any already incurred fees, including any escrow fee. But you can read all of these, but normally it's going to be this box here. And it's fairly simple. And on this page, this requires the buyer and seller to sign. On the first page, it's who's ever canceling the contract. First page will only have one signature if it's not a mutual cancellation. Okay, so if you're ever doing these forms and you're not sure, just ask us. We're happy to individually help everybody. I'm going to go over something really, really fast, and then we're going to go to questions if you have any here. I just want to reiterate, because we're still seeing some question marks on the buyer representation and broker compensation. Okay, you would check the property type, but I'm really interested today in talking about the amount of compensation. So here, you would only put your compensation, okay, not anything else, only the compensation that you're asking from the buyer that you will then ask the seller to pay later. Okay, so this is only yours, and that's the same with the listing agreements. Anything, if you're listing on the listing agreement, it's only the listing agent's compensation, nothing else. Okay,
That goes for leases too?
yeah, yeah.
Apartments?
Yes, it's only yours. Okay, so just make sure that you pay attention to that, because we don't want to be audited and then we were asking for more than what we were intending for ourselves. It's not for you to cover the other agent. Don't worry about the other agent. They'll ask for it.
Yeah, you cannot even include the unrepresented buyer.
Oh, really?
Either, yeah. Because you don't know whether you're going to represent the buyer or unrepresenting the buyer. It's a different situation. The first situation is that you represent the buyer, so you become the dual agent.
Right.
So you will get the listing commission as well as the selling commission.
Right.
But if the buyer doesn't want you to represent him, you can ask assist him to do the paperwork, but you don't represent him.
Oh.
Yeah.
Okay, so that's the difference. You cannot include that into your commission in that box either.
Got it.
Yeah.
On my listing agreement that I get on the property for lease, I check that for unrepresented.
Yeah,
agents.
you do check that, but the percentage that you put in the listing agreement, that's purely for your listing commission.
Yes.
Not for anything other than that. And even though later on you think that you will be representing or not representing, but you'll be helping the unrepresented buyer, you still cannot put that commission together with the
So,
diminished.
Right here. Here's what Peter's talking about.
yes, that
Okay.
I check it and I do 3%.
Right, that's fine, but additional compensation is what he's saying here. If
Yeah.
you put a percentage
Yeah, that's an additional,
purely for unrepresented buyer, purely,
yeah.
not for you, not for another agent.
Okay.
It doesn't just add into your pot. No,
So where does that money go to? I'm good.
that money goes to you if you actually have a transaction and you check the box. You have to check the box and put a percentage in there. If you did that, then let's say Joe is representing himself, then you can claim that, but you can't claim it just to put it into your pot. If there's another agent, it's purely unrepresented buyer. Does not apply to dual agency.
Yes.
Okay, So that's what he's talking about here. So just so you all understand that. Okay,
Okay, I'm kind of confused on that, Peter, and please apologize, man. Like this listing that I have. Someone called me and said, I want to see do you have an agent? No, I don't have an agent. I'll go over there and show it to you. And they
Okay,
like it.
okay.
So,
And then you still have to ask them whether you want me to represent you or you don't want me to represent you.
okay, if he say yes, okay.
Yeah, then you
But
become a
what if-
agent.
What if they say, no, I don't want you to represent me? Okay, so then write out,
Then you go to the seller and say, hey, seller, I have an unrepresented, buyer, but I'm still going to help him with the paperwork. So I am going to get the portions that was listed as an unrepresented buyer, which you have checked the box.
Yes.
Okay, that's it.
oh, okay, but it's still, so no matter what, if that tenant or buyer that doesn't want me to represent him, and I still end in doing the work,
Yeah.
I'll
You
get the
still
commission.
that. You can get this commission from the seller as long as you check the box of the unrepresented,
Gotcha.
Yeah.
Gotcha, okay.
yeah, but yeah, check the boxes,
Yes,
the
I checked.
operating. Yeah, does anybody have any questions for Peter or I that's on Zoom? Okay. They're saying my audio's not working. Can you guys hear me?
Yeah, I can hear you, Michelle. It's me.
Oh, okay. Okay, so it was just one agent, maybe he had problems with
But Michelle, I can't see your documents that you're going through. It disappeared. It was
No,
there. And
I just took the share off just to answer any questions if you have any.
That-
Yeah, does anybody have any questions, comments? Okay, so if you're going through a transaction that you don't understand any of the forms or anything, or you just have a question, make sure that you reach out to Peter or I. We're always here to help you and to make sure that you do understand them and to help you fill them out properly. So anything else?
Yeah, one more question.
Yeah.
We quite a while without being active on the leases. I put rent spree, okay, so they have to go to rent spree. Rent spree can run the credit report and it can check on the background of the particular
Okay.
prospective tenant.
Mhm.
Because I understood before that we cannot do that.
Why you can't do that?
Check on the background and see if they have any record.
You can always do that, why not?
So
Who said that you cannot do that?
I was kind of confused that on that it says that you cannot
Oh,
allow.
you can do it. Of course you can, that's that's the main due diligence, you do it for your client.
Okay, gotcha.
So I wanted to remind everybody that's here, if you haven't registered already for Monday, we have our Monday 10 a.m. meeting as usual, but at 1 p.m. we have a special lunch and learn on Monday for Tony Robbins. Tony
Oh, it's on
Robbins,
Monday.
yeah, but you need to register, please. Because they're keeping track with me who's registering. So there's an email out again today and Rhett has put the registration link in there. So if anybody has any, it's right here. It's gonna be here.
If you want to be in person, you can just come here.
Yeah.
But if you want to do the Zoom, you have to register.
Okay.
Yeah,
No food on Zoom.
yeah, they're not, and they won't be providing a link until late because they're trying to get people to come in person.
Yeah,
But we
there's
will-
Gonna be a lot of people.
Yeah, so make sure those of you who want to see an associate of Tony Robbins speak, it's going to be a good hour and a half.
Yeah.
Motivating. 1 p.m. with lunch, okay? Light lunch.
Excuse me, Michelle. So the person's gonna be there in person, or he's gonna do that class via Zoom?
If they put a fire, you can.
What'd you
walk
say,
up.
Oscar?
Don't walk up,
The
walking on fire.
person that's gonna do that class, is he gonna be there in person, or so he's gonna do it through